Morning. Today we are going to analyze one problem question based on LRA 2002. Kindly go through the disclaimer completely. The video content has been made available for informational and educational purposes only. Let's start with the problem question. In 2020, Mary purchased Miss Melthwaite Manor. Miss Melthwaite Manor is a mansion set in extensive grounds. In December 2020, Mary signed an agreement with her neighbor Ben. It gave Ben permission to use a shower room in an outbuilding belonging to the manor in return for a monthly fee of £10. Ben's house only has a bath. He uses the shower room at the manor once a day. In February 2021, Mary married Dickon, who moved into the manor to live with Mary and her former nanny Sowerby. Dickon is a retired doctor. He looked after the house as Sowerby became increasingly frail, and Dickon did more for the cooking, cleaning, and laundry. He also maintained the grounds. In May 2021, Mary leased the vegetable garden into the grounds of the manor to Colin for 5 years. This agreement contained a term allowing Colin a right exercisable for 5 years to purchase the vegetable garden and the adjacent secret garden for £50,000. Colin became annoyed and when Dickon helped himself to vegetables. He immediately erected a sign at the entrance of the vegetable garden that said, "Keep out, Colin's Vegetable Garden." In March 2023, Mary left Dickon to go and live with Susan. She sold the manor to Archibald. Archibald bought the property without taking any professional advice, and he did not visit the property until after the sale transaction had been finalized and he became its registered proprietor. On arriving at the manor for the first time, Archibald saw Ben is leaving the shower room before being surprised to find Dickon and Sorbet living in the house. They are both refusing to move out. Sorbet explained that she had used her entire life savings to help Mary buy the manor in 2020. Shocked by his discoveries, Archibald wandered into the ground to find Colin planting potatoes in the vegetable garden. He asked him what he is doing there. Colin ordered him to leave the garden. The next day, Colin wrote to Dickon telling him that he is going to be exercising the option in his lease to buy both the vegetable garden and the adjoining secret garden. So we have to advise Archibald on this situation. This case presents a complex scenario involving multiple competing claims to the manor, all arising during the Mary's ownership. The primary issue is whether these claims created before Archibald became the registered proprietor are enforceable against him. The Land Registration Act 2002 governs the priority of interest in the registered land, and its provisions will be crucial in determining the outcome. What is the Ben's easement? A Ben has a potential easement for the use of the shower room. However, the passage lacked details about how this easement was created, making it unclear whether it is legal or equitable. Comes to the legal easement. If the easement was created by deed, it would be a legal interest and would be registered on the title. This would automatically bind A under the LRA 2002. Equitable easement. If the easement was created informally, it would be an equitable interest. This would need to be protected on the register by a notice, or if B can prove he is in the actual occupation, it might qualify as an overriding interest under the Schedule 3, Paragraph 2 of the LRA 2002. Ben's right to use a shower room. Nature of agreement. Ben has a contractual right to use the shower room based on the agreement with Mary. This is a personal right, not a property right interest. Impact on Archibald. This right is likely not binding on Archibald, while Ben has a contractual right. It's not a registered interest and likely not an overriding interest under the LRA 2002. Archibald, as a new owner, is not bound by personal contracts made by the previous owner. Williams and Glen Bank versus Boland and Abbey National Building Society versus Can are relevant case laws here. They establish that purchaser is not bound by unregistered interest unless they are overriding. A Ben's right is neither registered nor likely to be overriding. In Celestial Limited versus Alton House Holdings Limited and Torture versus Douglas support this argument that openly exercised easement can override. The priorities under LRA 2002, under the legal easement for the with respect to the Ben's right to use a shower room, a legal easement is automatically registered as a minor interest on the register section 27.2 of LRA 2002. Therefore, Archibald is bound by it. With respect to the equitable easement may be overriding if it is obvious on inspection. And Ben is in the actual occupation, according to Schedule 3 of the Para 2 of LRA 2002. As Ben is using the sovereign daily, this condition may be met. However, Archibald lack of inspection before the purchase may be a factor. Ben has a right to use a shower room in the outbuilding in exchange of a monthly fee. This right is likely an informal lease, which may be an overriding interest under the LRA in 2002, particularly if it is exclusively possessed and obvious on inspection. What about the Dickens claim? Dickens has no clear basis for beneficial interest in the manor. He cannot rely on a constructive trust or a proprietary estoppel, as the facts do not support such arguments. He may be able to rely on his home right under the Family Law 1996, but this cannot be an overriding interest. Therefore, D would need to have protected his interest on the register by a restriction to be enforceable against A. What about Sowerberry's claim? Sowerby claim based on her financial contribution to the purchase of the manor in 2020. This could potentially create a trust interest for her. Priorities. If yes has a trust interest, its priority depends on whether it was protected on the register. A restriction would have been placed on the register to protect her interest. Overarching, if the purchaser money was paid to two or more trustees, the overarching may have occurred, extinguishing S interest and transferring it to the purchase money. Overriding interest. If S was in discoverable actual occupation of the house, her interest might qualify as an overriding interest under the Schedule 3, Paragraph 2 of LRA 2002. Yes contribution to the purchase might give her beneficial interest in the property. If this interest is established, it could be a overriding interest depending on its nature and whether it's exclusively possessed and obvious on inspection. As per Abbey National Building Society versus Kane and Choker versus Choker case, yes interest could have been protected by a restriction on the register, preventing the property from being sold without her consent. Williams and Glens Bank versus Boland, and Abbey National Building Society versus Cairn, and City of London Building Society versus Flegg, and Choker versus Choker established the principle of overriding interest and beneficial interest in the property. Yes claim. They argued that yes contribution to the purchase of the house in 2020 gives them a right to remain the property. This may be considered a resulting trust or a constructive trust, which are not automatically registered and may not be overriding interest. However, their long term residency and the lack of notice by A could be a relevant factors. Collins claim has a 5-year lease of the vegetable garden, potentially giving him a right to purchase the vegetable garden and the sacred garden. It would be automatically registered as a minor interest on the register section 27.2 of LRA 2002. It's binding A. This lease is likely a registered interest and would bind A as it is recorded on the register. The option to purchase may also be a registered interest depending on the specific terms. What are the priorities? If the lease was created by deed, it would be a legal interest and bind A. If not, it would be an equitable lease. An equitable lease can still have priorities under LRA 2002 if it is protected by a notice or if can demonstrate the actual occupation. What happens to the actual occupation? A sees erection of the sign stating "Keep out, Collins Vegetable Garden" could be considered as an evidence of actual occupation, potentially satisfying the requirement of Schedule 3, Paragraph 2 of the LRA 2002. The sign "Colin erected" might be considered as an evidence of occupation. Collins option to purchase. The C's option to purchase in a separate interest. It is unclear whether it was protected by a notice. If not, it may be an interest that gain dual protection under the Schedule 3 of Paragraph 2 of LRA 2002. If C can demonstrate the actual occupation of the land to which the option relates, the secret garden, the option to purchase is a legal right and is likely an overriding interest as per Choker versus Choker. Thompson versus Fay and the link lending versus Burstard or the relevant case here. It establishes that a purchaser of a registered land takes the subject to overriding interest. As whereas in Choker versus Choker is also relevant as it deals with the overriding nature of an option to purchase. What about the Dickens and Sawbury's right to occupy? Dickon and Sawbury situation is more complicated. While they are living in the house, their claim to occupy is based on the relationship with Mary and Sawbury's financial contribution to the purchase of the property. The cases like Williams and Glenbank versus Boland suggest that a spouse a beneficial interest in a property can be overriding interest if they are in actual occupation. However, Dickens' claim is less clear. His claim might be considered as a family interest under the Schedule 3 of Paragraph 2 of LRA 2002. Sawbury's financial contribution could strengthen her claim, but it is unclear whether her contribution was sufficient to establish a beneficial interest in the property. Abbey National Building Society versus Cairn City of London Building Society versus Flegg, these cases highlight the importance of proving a beneficial interest in the property to bind a purchaser. What about Archibald's position? Yes, as the registered proprietor is generally protected by LRA 2002. However, he is vulnerable to the claims from those who have successfully protected their interest on the register or who can demonstrate an overriding interest. What the lack of due diligence? Yes, failure to conduct due diligence before purchasing the property is problematic. He should have investigated the property and its occupants to avoid this situation. Let's conclude. To provide a comprehensive advice to A, the further investigation is required into the nature of the claimant's interest, the method of the protection used, and the specific facts surrounding the occupation of the property. The analysis should focus mainly on legal versus equitable interest, determine whether the interest are legal or equitable, as this affects their protection priority. When it comes to the registration, investigate whether the interests were registered or protected by the notices, the actual occupations to assess whether the claimants were in the occupation satisfying the requirement of Schedule 3 of Paragraph 2 of LRA 2002. So, based on the analysis, A can then be advised on the strength of each claimant case and the potential risk to his ownership of the manor. So, based on the information available, A situation highlights the complexities of the unregistered interest in the registered land. LRA 2002 aims to protect bona fide purchases, but it also recognizes the importance of protecting the existing rights. In this case, the lack of proper registration and disclosure by Mary has left is vulnerable to the claims of the previous occupants and the agreement holders. He is likely bound by their interest due to their actual occupation and the lack of registration of their rights. So, A's position is precarious. A is likely to bound by Ben's easement, Colin's lease, and possibly A's beneficial interest. Dickens' claim is unlikely to succeed since the occupant's lack of inspection before the purchase and failure to seek a professional advice significantly weaken his position. Thank you. I hope this analysis is very useful for you. Thanks a lot. and we'll meet in the next video.